Presumption. In presumption, we will study may presume, shall presume, and conclusive proof. Let's see an example first. Suppose this is you. You have seen smoke somewhere. By seeing smoke, you presume that there exists fire also. So, on the basis of smoke, you have presumed the existence of fire. This is known as presumption. Here you have proof only of smoke. You have seen only smoke. You don't have any proof of fire, because due to this wall you cannot see fire. Then also, on the basis of smoke, you have as presumed the existence of fire. This is known as presumption. Presumption can be done in two ways. You can presume anything by two ways. First is by logic and another is by law. How presumption is done by logic? Like in above example, on the you have seen smoke, and by logic that the smoke comes naturally from fire, you presumed the existence of fire. This is presumption by logic. Presumption by logic is known as presumption of fact. This presumption of fact is discretionary. The court has the discretion, it has the choice. The court may either presume that fact or it may not presume it and call for proof of it. The court will say, we will not presume it, you have to prove it by proof. In presumption of fact, there comes may presume. The word may signifies that the court has discretion to presume or call for proof of it. If the court has presumed it, then you have the option to rebut it by giving evidence. You can disprove the presumption. Another one is by law. If in law it is written that on the existence of A you have to presume B, if the law says this, then it is mandatory for the court to presume it. The court doesn't have choice to call for proof of it. So presumption of by law, it is known as presumption of law. It is of two types. One is shall presume and another one is conclusive proof. In shall presume, once the court has presumed something by law, then you can rebut it by giving evidence against it. You can disprove it. And in conclusive proof, once it is written in law that A is the conclusive proof of B, then you have to presume B. It is mandatory to presume B and you cannot give any evidence to rebut it. The court will not allow to give any evidence against B. Now let's see examples. First, there is presumption of fact. This one is presumption of law. In presumption of fact, there comes may presume. For example, suppose you are in a class. In that class, a student has an iPhone and his iPhone is stolen, and his iPhone is found in your bag. On the basis of this fact that it is found in your bag, the court may presume that you are a thief. The court has the option to presume you as a thief, or the court may call proof of it. That is, if somebody is accusing you of theft, then the court will ask him to prove it. Okay, so here the court has the choice. It may either presume you as a thief or it will not presume you as a thief and call proof of it. Both of this will depend on surrounding circumstances. Suppose you have done theft in past also. There is history of theft. So in that case, the court may presume you as a thief, or if you are a good student, the court will not presume you as a thief. It will call proof of it. So it will depend on the surrounding circumstances. If the court has presumed you as a thief, then you have the option to rebut it. You can provide evidence to disprove the presumption that the court has presumed false. Another one was presumption of law. In it there were two, shall presume and conclusive proof. In shall presume there was the option of rebuttal. You can rebut it, you can disprove it, but in conclusive proof there was no option of rebuttal. First we will see shall presume. Its example: suppose a lady dies and the lawyer of the lady shows in the court that the husband of the lady committed cruelty on her, he harassed her for dowry. Then in that case, on this basis, the court shall presume. It is mandatory on the court by law that it shall presume that the husband has caused the dowry death. But the husband here has the option to rebut it. He can provide evidence to disprove this presumption. Now comes conclusive proof. Suppose a child has committed a crime, and if the lawyer of the child shows in the court the birth certificate of the child and shows that he is only 7 years old, then on the basis of this birth certificate will be the conclusive proof that this child is innocent. So once it is it is shown that the birth certificate is shown, then it will be the conclusive proof of the innocence of the child, and there cannot be any rebuttal. You cannot rebut it, you cannot give any evidence against the innocence of the child. It is conclusive proof by law. The law says that if the child is 7 years or less than 7 years old, then this child will be considered as innocent. The birth certificate or any evidence of age will be the conclusive proof of his innocence, and no evidence can be given against it. So this was your presumption of law. Now let's see the theory portion. Presumption. It is not defined in the Bharatiya Sakshya Adhiniyam. The definition is not given in the Bharatiya Sakshya Adhiniyam. Its general meaning is, on proof of one fact, the court presumes the existence of other fact. There is no need of evidence to prove it. That is, if you see smoke, you have the proof of smoke, and the existence of this smoke, you presume the existence of fire. There is no need to give evidence of fire. This is known as presumption. In general, to prove a fact, you have to give evidence, but presumption is an exception to the general rule. In presumption, there are certain facts for whom there is no need to give evidence to prove them. They are presumed as proved by logic or by law. In generally, if you have to prove any fact, you have to give evidence for it. But presumption is an exception to this general rule. In presumption, there are certain facts which can be presumed as proved by logic or by law. We have already seen by logic, that is presumption of fact, in it comes may presume, and by law, in it comes presumption of law, that is shall presume and conclusive proof. So what are the kinds of presumption? One is presumption of fact, another one is presumption of law. In presumption of fact, there comes may presume. In presumption of law, there comes shall presume and conclusive proof. The shall presume is rebuttable. Evidence can be given against it to disprove it. In conclusive proof, it is irrebuttable or irrefutable. That is, no evidence can be given against it to disprove it. The word irrefutable is in bold letters because sometimes in exam, the examiner asks the direct question, what is irrefutable presumption? So irrefutable presumption is same conclusive proof. You have to write conclusive proof. The definitions. The definition of may presume is given in Bharatiya Sakshya Adhiniyam section 2(1)(h). It says, where the act declares that the court may presume a fact, the court may either presume that fact unless and until it is disproved, or may call for proof of it. That is, somewhere in the act, if it is declared that the court may presume, then the court has the option, it has discretion to either presume that fact until or unless it is disproved, that is rebut is given, or it may call for proof of it. So here the court has the discretion to presume or call for proof of it. When it presumes until and unless it is disproved, that is until and unless it is rebutted, evidence is given against it. It means it is debatable in nature. Other party may adduce evidence to disprove it. Further, by using may, it is clear that the court is not bound to presume a fact. This power is discretionary. The court has the choice. The court may presume the existence of any fact which it thinks is likely to have happened. For case law, you can write Roney versus State of Maharashtra. In it, the court said, if soon after the offence of robbery, property robbed is recovered from the possession of the accused, it be presumed that he has been involved in the offence. Now comes shall presume. It is rebuttable. Its definition is given in Bharatiya Sakshya Adhiniyam section 2(1)(l). It says, where the act declares that the court shall presume a fact, the court shall presume that fact unless and until it is disproved. It says, somewhere it is written shall presume, then the court have to presume that fact until and unless it is disproved. That is, until and unless rebut is given, there is option of rebuttal. Here the court has to presume, there is no option to call proof of it, there is no option of it. The court doesn't have discretion here. By using the word shall, no room for discretion is left to the court. It is mandatory for the court to presume that fact. However, such presumption can be rebutted by the other party by adducing evidences. Example, where the question is whether a person committed dowry death of a woman, the court shall presume that such person has caused the death if it is shown that soon before her death she has been subjected to cruelty and harassment for or in connection with any demand for dowry. So here, if it is shown that a person has committed cruelty and harassment for dowry on a woman and this woman dies, then this will be, the court shall presume by law that this person has committed dowry death of that woman. For case law, you can write Hardhan Mahatha versus Dukhu Mahatha. Here the court said where the expression court shall presume is used, in that event court has no discretion. It has to regard such fact as proved unless and until it is disproved. Last one is conclusive proof. It is irrebuttable or irrefutable. It is given in Bharatiya Sakshya Adhiniyam section 21b. It says where one fact is declared by this act to be conclusive proof of another, the court shall, on proof of the one fact, regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. Here it is said that if it is written that A is conclusive proof of B, that is, if it is written that if the child is of 7 years or less than 7-year-old, then it is the conclusive proof of his innocence. Then in that case, this will be presumed as proved that he is innocent and no proof can be given against it, no evidence can be given against his innocence. Thus, once presumption is made, it cannot be rebutted by the other party. The latter will be barred to adduce evidence to the contrary. For case law, you can write Queen versus Lukhini Agradanini. In it, the court said mere evidence of age would be conclusive proof of the innocence of the child. So this was your may presume, shall presume and conclusive proof. The PDF notes of this subject, Bharatiya Sakshya Adhiniyam, they are available at www.lockup.com. You can get this from this website.